All right, so here I am, worn out. I got another trial starting for 6 weeks possibly, and so I was looking at a DirectD video. You guys really liked the other one that he put together for Richard Weed, who was driving around in a bait truck. Anyway, there was an update to the case. Here's the beginning of the video. This is an amazing video. It's a bait truck.
Jeez. As soon as I saw the rainbow line square, I was like, yep.
Did you guys recognize it?
I slowed down.
No, did you see the back? It's like, fuck police and all that stuff. Okay.
That's exactly what I pulled over from.
Alright. Oh.
So right there, you have the admission from the cop as to why these guys were pulled over in their truck. And remember, they weren't out looking for attention. They were just trying to see if attention would come to them. Anyway, there's now an update that DirectD did.
This pro se defendant is crushing the state's case in Mesa, Arizona. It's crazy. This video is meant to show the events in order, followed by the current court battle Richard is facing. And frankly, Richard is absolutely owning them in court right now. Check it out.
Now, to save time, Richard is putting together motions to try to suppress evidence that he thinks would be for an unlawful search, et cetera, et cetera. And one of the key things here was there's an Arizona law that says that you have to answer the cop if he asks you if you have any concealed weapons on you. And Richard said, I do not answer questions. I think, and again, I'm not an Arizona lawyer, but just I think they have a Fifth Amendment right not to incriminate himself. Now, these motions that he filed, they all were denied, filed their responses, really be in opposition as opposed to a response. And each time there was an assertion that the search is illegal, he said dismissal. And Richard really did a nice job, writing these up. A couple of things jump out to me, but this is not a criticism of him. You would normally want a declaration to now create evidentiary facts as opposed to just argument. And secondly, whenever you do motions like this, you now have to worry about contested issues, which have to be resolved by a trial, by a judge or a jury. What you want to do is argue what's undisputed. And what I'm not seeing that's being argued, maybe I'm just late to the game, is because I haven't really followed the case, is why aren't we talking about the pretextual reasons for the stop? And Arizona law, as I'm going to show you from the Supreme Court case, says that pretext stops are legal. A pretext stop would be a BS reason for pulling someone over, you just make it up. But as long as there's some other reasonable grounds, then even the pretext won't matter because there's still a legitimate basis for the stop. So I took a look. The next hearing is on April 23rd, pretrial hearing. Here are the previous motions that were denied, 2 motions to suppress. Shows that he's being charged with misconduct of a weapon, failed to answer questions. I think that statute is ripe for attack as unconstitutional, but we'll see. There's one case I wanted to show is State versus Herrera. And there are, disclaimers here. I'm not doing Arizona law. I'm not an Arizona attorney. This is not a legal opinion. This is just me commenting on a public issue. I'm a California licensed lawyer. I'm not licensed in Arizona. It has its own rules, its own, everything. Not binding. It's not legal advice. You get all that. And this also is not a decision you can be relied upon. It's not citable, but I wanted to look at something that happened in the Court of Appeals in Arizona. It's an unpublished opinion. This is citing to actual Arizona authority. Traffic stops are seizures within the meaning of the Fourth Amendment because they are less intrusive than arrests. An officer need only reasonable suspicion that a traffic violation has occurred to initiate a stop. And the violation of a traffic law is sufficient grounds to stop a vehicle. So if you have a tail light out, whatever, that's good enough. If I remember correctly, the cop said that it was an abnormally loud exhaust of the truck. Now, here's where we start getting into undisputed facts, which would be a big help to Richard. We recognize that pretext traffic stops are permissible if otherwise supported by reasonable suspicion. This case, Wren versus United States Supreme Court case, this is the one where they were pulled over. They said the cops issued a pretext about violating the traffic law because they didn't make a safe lane change. Drivers were saying, no, you really pulled us over because we're black, and you just made that up. However, because they admitted that they did violate the traffic regulation, that in itself was sufficient now for reasonable suspicion. But the Constitution prohibits selective enforcement of the law based on considerations such as race. The constitutional basis for objecting to intentionally discriminatory application of laws is the Equal Protection Clause, not the Fourth Amendment. So This case is saying that if you're bringing your defense under the Fourth Amendment for selective enforcement, it's the wrong thing. You got to equal protection under the 14th Amendment because of selective enforcement. It's important. If you are looking at a Fourth Amendment test for an extraordinary situation, that's when balancing factors come in. And it was for body cavity searches and things like that. You could engage the court into a balancing factors if you can show that this was an extraordinary situation. Jones versus Sterling is referenced. It's an Arizona case, went to Arizona Supreme Court. And this is interesting. If Richard is claiming, I don't know if he is, I'm just in case he is, if he's claiming indigent status or qualifies as indigent, and again, I'm not saying he is, the state would be likely forced to pay for his expert to defend his case. Then it talks about a very famous case, constitutional case, Yick Wo, and San Francisco put up regulations that looked perfectly objective on their face, but they're really intended to discriminate against Chinese. And it had that effect because essentially every one of them but one got rejected. It says, it may be fair in its face and impartial in appearance, yet if it applied and administered by public authority with an evil eye and unequal hand, so as to practically make unjust and illegal discriminations between persons in similar circumstances, the denial of equal justice is still within the prohibition of the Constitution. That facially neutral traffic laws were being used as a means to attack people they do not like. That's part of the hurdle here. And then this is interesting. Courts have long entertained 14th Amendment selective prosecution challenges to criminal prosecution as a defense, and they even cite to an Arizona case. The court held that a selective prosecution claim is not a defense on the merits of the criminal charge itself. It's instead an independent basis for dismissal because of a forbidden application of executive power. The claimant must demonstrate that the state action had a discriminatory effect and it was motivated by a discriminatory purpose. And one way to prove animus and arbitrary and selective enforcement, are statistics, which is what they used in the Chinese laundry cases here. But statistics of themselves, no, you still have to prove discriminatory intent. So there you have it, very short summary. Again, not legal advice, but I would be looking at dismissal of the case on undisputed facts, not disputed facts. It would be first, there is a pretext stop here as admitted to by the cops. Then next, I would be looking at the muffler or the exhaust pipe, and I would have it tested. That would be objective. How many decibels emitted from the exhaust? Then I would look at what the Arizona statute would be for permissible noise level. If I want to kick over my CR 500, believe me, they're all coming out. That's a violation. But I didn't hear an abnormally loud exhaust. So if it's tested and it shows that it's below the statute for that violation, and then we have the admission of a pretext, those are undisputed facts. If there's no violation of that statute combined with a pretextual stop that was also something that would potentially violate your rights, then you can't get to the point of going for a prosecution, it would seem, because everything has to be tossed now, as opposed to just simply arguing, throw out at the point where the cops are looking at the gun. I would be focusing before that, and then everything after that falls. And you would do that through undisputed evidence. Anyway, your lawyers can tell you all about it, and but it's a very intriguing case here. Of course, the cops are innocent. I'm not saying they broke any laws. This is all just making assumptions here, and the assumptions are based on what I have in front of me. But interesting case, and everyone's entitled to their presumption of innocence, including the cops, including Richard here. And we'll just have to let the cops and the prosecution and Richard go to town on that, and I'll just sit, eat popcorn, and watch. Thanks, everyone. Hope you enjoyed the video.